In this video, I'm going to explain how to use a preliminary hearing, a probable cause hearing in California, to find out what evidence the DA, the DA's witnesses, etc., have against you that they have not already turned over. And this is part of a series on preliminary hearings, so if you are interested in this topic, I would encourage you to view all of the videos that I'm making about preliminary hearings. I'm trying not to make this a super long, giant, classroom master class sort of situation, but there is quite a bit that goes into preliminary hearings, and I think that it is important for every criminal defendant and any loved ones who care about what's going on to learn this. My name is Veronica. I am a criminal defense attorney here in Los Angeles, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their freedom and their lives. And again, this video is going to be about how to use a preliminary hearing to figure out what evidence has not already been turned over that may exist out there in your criminal felony case. Now, look, one of the most surprising things to me when I ever started doing criminal defense is I would think that if you get arrested for something, like let's say they have a warrant out for your arrest, whatever, they arrest you for something, there's a stack, there's a whole pile of evidence that they've used to determine, yes, we want to bring a criminal case against Veronica. And then when you go to court and you get an attorney, of course, there's a copy of this giant pile of evidence given to your attorney. This is not how it works, or not at least how the DA and the prosecution would like it to work, and not really how, even as a defense attorney who's very annoyed by this whole thing, how we can really get it to work. So here is how it goes. And I know this is about the preliminary hearing, but let's go back and we'll talk about the first court date. At the first court date, all and almost every single case that your attorney is going to get is a police report. We'll just get paper. You could have robbed a 7-Eleven. I mean, this is a case I've actually had a few times. Do not rob a 7-Eleven. It is on HD video. But I won't get that HD video at the first court date. All that I will get is a police report, right? And you would think, especially if there's going to be a really high, if my client's in custody, right? He's in jail and it's $1 million bond. You would think that they would have, and I've actually had a client where he had $6 million. You would think that the stack of shit that they have against him, the stack of evidence, would be just turned over right then. They have it, right? That's why it's $6 million. Not so. Not so. And in fact, a lot of discovery is not, you're not entitled to as a defendant until 30 days before trial. Very annoying, because 30 days before trial, that means that you've probably rejected some deals at that point. They probably told you, hey, if this gets out for trial, we're taking these deals off the table, etc. It's very, I think, unfair. I think that it should be, if they want to, I really think that there should be some kind of system where if they want to set a bond for you for a certain charge, you should have to submit all of the paperwork, all of the evidence to a magistrate, a judge. Judge reviews them and decides, is there enough here? And also the defense gets that shit right then. We don't have to wait or specially request the body-worn video like we have to do now. But this is the system. The thing is that politicians in general are not pro-crime, pro-criminal defense, and so we have to work with what we have. We have, as much as the Founding Fathers get shit, the Founding Fathers were actually pretty pro-criminal defense, and the Constitution is one of the only things that is keeping the state from just locking people up without even providing sufficient evidence to attorneys. Anyway, many times before a preliminary hearing, and especially if my client is in custody, I will have asked the DA for body-worn video, for witness statements, for if the witness, maybe it will say in the police report, the witness says that they took pictures or whatever. I will have asked for those things many times, and I may or may not have them. I may have only 50% of them. If I file a motion to get them, I will be told by the judge, you are not entitled to them until 30 days before trial. Now, the DA's office, they're dicks in some ways, of course, they're the DAs, but they're not really dicks in terms of giving this stuff to us. But the problem is that it's a whole process. They have to get it from the police. The police are the ones who are dicks and don't turn it over initially to the DA, and then it's this whole thing about getting it from them. And part of this, I think, is that most criminal cases will plead out, like everybody will accept an offer on their first or second court date, so it's like, well, what's the point, right? But this is like probably one of the most annoying problems to me, and many of the judges are former prosecutors. So when I make a big deal about this, the judges act like I'm the crazy one. But hey, you're keeping my client sometimes in custody, or he had to pay a huge amount of bail in order to get out. Shouldn't the state have their shit together? Just, I don't know, maybe I'm crazy. Anyway, sometimes when we look through the discovery, the evidence in a case, we will have questions that we want to ask officers to confirm, the police officers to confirm, or witnesses to confirm the existence or non-existence of certain pieces of evidence. So examples are, did you test my client's clothing for gunshot residue, or did you collect any video from the scene? And it seems like I should know this before then, but if it's been months and we technically don't have a right to it yet, and I've been requesting it and I don't have it, I may not have it by the preliminary hearing, and I need to make sure that I ask these questions, because if the case does go to trial, I don't want to ask a question that I don't know the answer to, and I made a video about that. But this is our chance to ask the officer these questions and to require the officer to answer, and it avoids the possibility of being surprised later on, which is really what I need to avoid for every single one of my clients. We do not want to be surprised at trial. We want to know before trial, because going to trial is such a huge risk. No matter how great you think your case is, no matter how great your attorney is, it's such a huge risk that you want to know beforehand, like, what am I dealing with? What is the evidence against me? I don't want them to pop out with evidence against me at the last minute and then have a shitty judge like decide that, yeah, that's fine. One final thing about this is that discovery is actually not a valid reason to ask questions at a preliminary hearing, but in my opinion, every good defense attorney is going to try to slip those questions in if we are missing items that we think exist throughout the preliminary hearing. So sometimes, sometimes I will ask a question like, and did you take any photos of the alleged victim's injuries? And the prosecution might object if they're not, many times, like, honestly, they use like interns for this, so sometimes they're half fucking asleep, but sometimes they'll object and say, objection calls for discovery. And then the judge has to decide, does it call for discovery or not? Because this is not a hearing for the purpose of this hearing is not supposed to be for me to be able to ask, like, hey, what evidence did you collect? What evidence do you have? It's supposed to be for the prosecution to establish probable cause. But most defense attorneys are able to slip a lot of questions in, even if you have that like very overeager DA intern who's like, objection calls for discovery, and the DA keeps sustaining, or the judge keeps sustaining. Eventually they get kind of tired of it, so I think just keep doing it. Whatever. If they get pissed off, you have an intern and a judge who you're going to be transferred to a different courtroom very soon, who are like annoyed because you're trying to get information that you should have already, that should have been turned over to you already. Anyway, I hope that this video was informative. This is probably one of the longer videos in this series about what to expect in a preliminary hearing. And I would encourage you, if you're watching this video, you should just watch all of the videos about the preliminary hearing. From me, if there's anything else from another attorney that you think is helpful, like, watch those. But I'm trying to include all of the information that I possibly can, which is why I'm not doing one giant video, so that people can actually I really think that everyone who's accused of a felony in the state of California should have this information. Their family, their parents, they should have this information so that they know what to expect, what should happen, what can happen, what's unlikely to happen, what's likely, all of that at this pretty important event that often does not explain that well to people. If you do have a criminal case in Los Angeles and you do want to set up a meeting, feel free to go ahead and book an appointment down below. You can also go ahead and give me a call. My number is down below.